application of Nealon versus Secretary of State for Justice.
This is a historic day for this court. Last year, we were delighted to welcome Lady Arden as a Justice of the Court, and today, her husband, Lord Mance, is about to deliver the judgment in the case of Hallam and Nealon. This is the first time in this court that we have had a husband and wife team sitting on the bench. But of course, we do that without in any way diminishing our normal practice, which is that husbands and wives should not sit on the same case. But no doubt Lady Arden will be just as interested as the rest of us to find out what the answer is in the case of Hallam, or cases of Hallam and Nealon. Lord Mance will now explain the judgment of the court.
The appellants, Mr. Hallam and Mr. Nealon, were convicted of various offences. After spending 7 and 17 years, respectively, in prison, their convictions were quashed as being unsafe in the light of freshly discovered evidence. They have claimed but been refused compensation. They now seek declarations that the English law governing compensation is incompatible with Article 6.2 of the Convention on Human Rights, that is, the article enshrining the presumption of innocence. The appellant's applications for compensation were made under Section 133 of the Criminal Justice Act 1988. As originally enacted, that section gave a right to compensation where a freshly discovered fact showed, quote, conclusively that there had been a miscarriage of justice, and the meaning of that phrase was examined by this court in 2011 in Adams against the Secretary of State for Justice. This court held there that a miscarriage of justice covered 2 cases. Firstly, a case where the fresh evidence shows a defendant to be clearly innocent, and secondly, a case where it so undermines the evidence against the defendant that no conviction could possibly be based on it. However, the concept of miscarriage of justice did not cover a case where, thirdly, the fresh evidence merely rendered the conviction unsafe, in particular because in its light a reasonable jury might or might not have convicted, or fourthly, a case where something had gone seriously wrong in the prosecution of the offence or conduct of the trial. Parliament in 2014 then amended Section 133 by Section 175 of the Anti-Social Behaviour, Crime and Policing Act, so that compensation only became payable in the first case. In other words, where the freshly discovered evidence shows beyond reasonable doubt that the defendant didn't commit the offence. The Secretary of State for Justice in the present case refused the appellant's applications for compensation on the ground that this test was not satisfied. And the Court of Appeal Criminal Division had, as it pointed out, the CAD, merely quashed the convictions as being unsafe, in other words, as falling within the third category and not within one of the first 2 categories. The appellants now seek declarations, as stated, that the amended test introduced in 2014 is incompatible with the presumption of innocence. By a majority of 5-2, this court dismisses the appellant's further appeals to it. Lord Mance delivers the leading judgment. Lady Hale, Lord Wilson, Lord Hughes and Lord Lloyd-Jones deliver concurring judgments. Lord Reed and Lord Kerr dissent. The appeals require this court to consider how far its reasoning in Adams can and should stand in the light of a later European Court of Human Rights decision in Nealon against the United Kingdom in 2016. In Nealon, the European Court was actually concerned with a Case 3 situation, in other words, one where the fresh evidence simply rendered the conviction unsafe, and there was no attempt by the defendant to bring the circumstances within either Case 1 or Case 2. But the court examined its previous case law and indicated that the relevance of the presumption of innocence outside purely criminal proceedings depended upon the existence of a link with the criminal proceedings, and that could be a purely linguistic link, and that there were potential distinctions between compensation and third-party claims, as well as between claims following upon what it regarded as true acquittals and mere discontinuance. For present purposes, what is particularly important is that it also remarked that what was important above all in Allen was that the English courts had not required the applicant to establish a test of demonstrating her innocence. The present appellants, not surprisingly, rely on this remark as indicating that the amendment of section 133, which confines the right of compensation to cases within situation 1, where an applicant can demonstrate that he or she didn't commit the offence, is incompatible with the presumption of innocence. As to this, and as to the scope of the presumption of innocence outside purely criminal proceedings, Lord Mance considers that the concept of a link is in fact a diversion from the real question, which is whether the court, in addressing the other, normally civil claim, has suggested that the criminal proceedings should have been differently determined. If it has done that, then it's exceeded its role. Lord Mance would refuse to depart from Adams or to follow the case law of the European Court of Human Rights if and insofar as that court may in the past have gone further than that. But second, even if that is wrong and the presumption of innocence is more widely engaged, it is a separate question whether section 133 as amended is incompatible with the Convention. That question has never been directly before or decided by the European Court, and Lord Mance is far from confident that the court would conclude that there is any such incompatibility. The prosecution must be able to submit that the fresh evidence does no more than show unsafety within case 3, which is in fact all that it showed in Allen itself, where the European Court held there was no right to compensation. And it's difficult in convention terms to see any sensible distinction between requiring an acquitted defendant to show that the fresh evidence so undermined the conviction that no conviction could possibly be based upon it, which Allen indicates to be legitimate, and on the other hand requiring the defendant to show that it demonstrated his or her innocence. Lady Hale is also persuaded that although in general the Supreme Court will find that an applicant's rights have been breached where it's clear that the European Court would find a violation of the Convention, that is not clear in this case. She agrees that Article 6.2, the presumption of innocence, is engaged, but it doesn't follow that the European Court of Human Rights would automatically find a violation. She agrees with Lord Mance that the real question is, or ought to be, whether a civil court has suggested that the criminal proceedings should have been determined differently. There is enough in the evolution of the European Court of Human Rights jurisprudence to suggest that this is, for the most part, also that court's approach. It's also inappropriate to contemplate any declaration of incompatibility in proceedings such as the present brought by an individual in respect of whom the European Court of Human Rights in Strasbourg would be unlikely to find a violation, the present being, like Allen, on its face, if one takes the CCAD's findings, a case of simple unsafety within case 3. Lord Wilson dismisses the appeal on the simple basis that the European Court's case law regarding the operation of the presumption of innocence outside the criminal sphere is confused to the point where, even recognizing the likelihood that the appellants could successfully apply to that court for a ruling of violation, that court's jurisprudence cannot and should not be followed domestically. Lord Hughes dismisses the appeals for reasons which overlap substantially with those of both Lord Mance and Lord Wilson. He points out that different legal systems adopt different compensation schemes for those wrongfully convicted, and that the European Court has been at pains to say that neither Article 6.2 nor any other rule provides an unqualified right to compensation. Anyone seeking compensation must satisfy the eligibility requirements. Further, even if there existed a workable test for finding a link between an earlier, eventually quashed conviction and a later compensation claim, such a link would not here exist. Lord Lloyd-Jones agrees with Lord Mance as to both the scope of the presumption of innocence and the lack of any reason for distinguishing under the Convention between cases 1 and cases 2. Having regard to the unsettled state of the European Court's case law, he is not persuaded that Section 133 is incompatible with the Convention and believes the matter requires consideration in Strasbourg. Lord Reid and Lord Kerr dissenting would have allowed the appeals. Lord Reid, with whom Lord Kerr agrees, generally considers that the European Court's judgment in Allen establishes that a sufficient link exists to engage the presumption of innocence. The Supreme Court should follow the Grand Chamber's judgment in Allen because it was carefully considered based on detailed analysis of the case law and consistent with long-standing authority and had been followed subsequently. He accepts that the presumption of innocence creates no right of compensation in cases 3 or 4, where all that is found is unsafety or a serious defect, but Section 133 as amended is, in his view, incompatible with the presumption of innocence. Lord Kerr also rejects Lord Mance's formulation of the relevant test on the ground that it would cut out, in his view, deserving applicants unable to prove their innocence and would determine their fate by phraseology which happened to be chosen by the court.
Thank you.